Good afternoon, everyone. Thank you for joining us today for the online talk. We should be starting shortly in about 5 minutes. And for those of you who are here early, thank you very much for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled How to Close Up Shop, Dissolution, Voluntary Winding Up, and Striking Off a Company. My name is Alicia Chin. I'm an associate with Voluntary & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Voluntary & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Weng Kwai. Our able team today comprises 29 lawyers and a support team of 35. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolutions team. Today's talk is a part of our Voluntary online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice on your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. We have two speakers today, Mr. Sebastian Liew and Mr. Aaron Liew. Sebastian is a senior associate with Voluntary & Associates, and his practice areas include corporate litigation and company law advisory. Sebastian graduated with a Bachelor of Laws from Cardiff University and obtained his Master's in International Finance Law from the King's College London. Sebastian was called to the English Bar in 2015 and called to the Malaysian Bar in 2018. Aaron is an associate with Voluntary & Associates, and his practice areas include corporate advisory and dispute resolution. He graduated with a Bachelor of Laws from the University of Manchester and was called to the English Bar in 2020 and admitted to the Malaysian Bar in 2021. Aaron will be speaking first and giving us an introduction to the dissolution of a company before moving on to the striking off of a company. following which Sebastian will be speaking, and Sebastian will be touching on the voluntary winding up of a company, which includes a member's voluntary winding up and a creditor's voluntary winding up. We will then conclude with a short Q&A session. So if you have any questions at all, please don't forget to type it in the Q&A chat box below. And without further ado, I will pass it over to Aaron to begin our session for today.
Thank you, Alicia. Good afternoon, everyone. Welcome to our talk. So today I will be giving a short introduction to what dissolution of a company really means. So basically, in Malaysia, there are two common business structures under the Companies Act, which the first is, of course, as everyone knows, the Sendirian Berhad, the private limited companies, and also the public limited companies, which is Berhad. These are the public listed companies. So a company essentially is a separate legal entity compared to a person, an individual. So they are separate from their shareholders and can own, buy or sell property just like how a person can do. An individual can enter into a sales and purchase agreement with a developer to buy a property. A company can do so as well. They can enter into legal contracts or arrangements. They can sue or get sued by anyone else in the courts. And also, for the purpose of our talk today, they die because as a result of a dissolution of the company. So this is essentially what a company is as an artificial person. Technically speaking, in legal terms, they are not much different than a human being. So a company limited by shares, they can be incorporated and even through the following procedures. There's one director reside in Malaysia by having a primary residence in Malaysia, and there's a name came up from your mind and you want to reserve it with the SSM. That's the name that you're going to name it for your new company. You pay for the incorporation fees. And after the incorporation of the company, you have to appoint a company secretary within 30 days. These are the very short and brief process to incorporate a company. So I believe some of you may have already gone through the process a long time ago and currently still conducting business using the same company. However, for the purpose of our talk today, we are talking about dissolution of a company, which technically means that you do not want to continue business or whatsoever. So how can you dissolve a company? Usually, a company may be dissolved either by the SAM's registrar, shareholders, the directors of the company, creditors, for example, any creditors that you owe money from them, or liquidators. But because of its nature as an artificial person, the company cannot dissolve on its own, which means that you need essentially some of these persons up here to dissolve it on its behalf. So like I have mentioned just now, some reasons why a company is being dissolved, and maybe in your mind as a director, you want to shut down a business, close down a business because the business operations are halted, or let's say you have already created a company, but it remained dormant for a couple of months or maybe more than a year or so. And you decide that since you have also, probably you have a couple of companies and it's just a waste of time and effort to run so many companies, and you decide to group everything together. That's why you left some of the companies dormant. And as like a dormant company, the company has no assets or liabilities. They have nothing, essentially. It's no longer profitable, or they owe a lot of debts towards other creditors. In this scenario, some of these reasons can be used for striking off a company and also voluntary winding up, because that's essentially the reason why you want to shut down a company. So these are the few main reasons that we are talking about. Now, coming to the dissolution of a company, under the Companies Act 2016, there are two main ways to dissolve a company. The first one would be the striking off a company. This is the more efficient, quick, and simple way to dissolve a company. The second one would be the voluntary winding up. This is much lengthy and more costly because it involves a lot of different parties as well. Under the voluntary winding up, under Companies Act, we also have the members' voluntary winding up and also a creditor's voluntary winding up. So I'll be talking shortly on the striking off of a company, and Sebastian will be touching on the voluntary winding up part. Now, striking off a company. Pursuant to the Companies Act, a company may be struck off by the registrar or by the company's own motion, for example, shareholders or directors. So under Section 550 of the Companies Act, it reads that the registrar may strike a company off the register either on its own motion or upon an application by a director, member, or liquidator of the company. So basically, it means that the registrar deems that the company is dormant or not having any business operation based on the SSM's record, then they may, of course, strike off your company. Or if anyone wants to apply to strike off the company, they will also have to take into consideration whether it would really be able to strike it off or not. So why strike off a company? Some reason, as I mentioned earlier just now, to strike off a company mainly because there's no business operation, there's no profits coming in, and the company remain dormant or has not been doing any business for quite some time. And because the shareholders passed away or they died, for example, the directors has been conducting the business for quite some time, but they have no idea where the shareholders are, and there are some major business decision has to be made and has to go through the shareholders, but they're unable to trace them. So this is one of the problems that result the company in a stalemate, and they decide to let's just dissolve the company or whatnot. And also because striking off a company is a much cheaper, much quicker, and more efficient way compared to the winding up process. So let's say if all the members, all the directors get on a mutual consensus, let's just terminate the company down or whatnot. Striking off is the quickest way to do so without going through the lengthy process. Let's say you have to go through the creditors meeting or the resolution, which we'll be talking on later, and it's much more straightforward. It does not require a lot of effort to really do it. So these are some of the reasons that why a company wants to strike off. Now, as I mentioned just now, who can strike off the company? Usually under Section 549, it will be the registrar, and then the shareholders, the directors, and the liquidators. So if the registrar found out under the SSM system that a company does not submit any annual returns or never lodge any audited financial statements, or which something that raise a reasonable suspicion that the company is not conducting any business operations, activities, or transactions whatsoever, the registrar will have reasonable belief that it's a dormant company and no longer in operation, which is why sometimes we will face a lot of problem that this company all of a sudden it's already struck off the register already being gazetted and no longer exists, as if it's already been dissolved. So sometimes these are the reason why the registrar would want to strike the company off, mainly because you have never submitted any audited financial statement or anything that prove that the company is actually conducting any business operations. Now, the next part is when it comes to how to strike off a company. Let's say you have already come to your mind that, okay, I'm going to strike off my company, dissolve my company, what should I do next? So under the SSM's guidelines on application by directors or members to strike off the name under Section 550, there are 10 requirements that the certain company would have to fulfill. So the first off would be like the shareholders have to pass the resolution approving the application to strike off the company on the grounds that it is no longer operational. What defines operational in Liew Berhad against Ong Chin Ho, which they define that operational includes any engagements in negotiations and correspondences, even if there were no business transactions whatsoever. Meaning that let's say you wanted to enter into a project, but actually before the project actually concluded, both parties signed any agreement and you wanted to decide to dissolve your company, but actually at that point of time, because you were engaged in negotiations and correspondence, you were technically, the company is still operational. So in that sense, it wouldn't be very feasible or not a strong valid ground to strike off the company. The next few is the company has no assets or liabilities. So for example, maybe you have purchased some assets and right before you wanted to dissolve your company, you have already sold most of it and there's nothing else left other than just, for example, a shop house that you rented to conduct your business. You can just, of course, it's one of the requirements to apply to strike out on the basis that you have no assets or no debts under your name, and you have no outstanding charges under the registrar of charges, no outstanding penalties under the Companies Act or under any other government authority, or no outstanding tax or any other liabilities with the government authorities. For example, maybe you owe some corporate tax with the LHDN and you have already paid them up. And after that, you decided to terminate, to dissolve the company, then that's fine because you have already hit the requirement to strike off a company. And the few others is basically is not involved in any legal proceedings and the information is updated in SSM's register. How many shares you have issued, how many directors, how many shareholders, your business address, everything, all these financial statement, audited annual return, everything, all these documents are all updated in the SSM register. and they have yet made any return of capital to any of the shareholders. If the company still has its capital, perhaps it will be better to proceed with voluntary winding up process, because that would subject to a lot of different calculations of debts, monies, and all the trade receivables and whatnot. And also the last two, the company is not a holding company and not a guarantor corporation, meaning that it's not a company holding for another on behalf of another company, subsidiary or whatnot, and also not a guarantor for any liabilities of any other companies. Now, the next part of this talk is about the procedures to strike off a company. As I have spoken quite earlier just now, it's a fairly simple and straightforward process. To file an application to strike off a company applicant director, shareholder, or these two persons must complete a declaration for the application under Schedule B of the Practice Directive 1/2017, together with all the documents in the checklist. I believe this declaration for the application can be found on the SSM website. After filling in all the information, submit the application to the registrar with the application fee, if I remember correctly, is around 100 ringgit. And the process usually will take around 6 to 12 weeks time. So once you submitted the declaration and once all documents have already been completed in the checklist, you take everything, submitted it to SSM. Basically, you just wait for the registrar to go through and see what the registrar would do. So once the registrar receive your application, receive your declaration, they will go through and see all the documents in the checklist and perhaps see your annual returns and everything, your SSM information, which is why your SSM information comes in handy here, because they would want to see what's the updated status of your company information before they decide to strike it off. So if they are satisfied that, let's say, oh, the company information are up to date and all the documents in the checklist are all completed, there's nothing else, they will approve the application to strike off. Once they approve it, a notice of publication of the notification and gazette will be issued to effect the strike off of the company. So this one we'll have to wait until the publication of the gazette. Only then the company is struck off the register and dissolved under Section 551 sub 3. So Section 551 says that the registrar shall publish the name of the company which has been struck off in the gazette, and upon publication in the gazette, the company shall be dissolved. So technically speaking, as long as the notification to strike off the company is yet to be gazetted in the gazette, the company is technically still not struck off. Once the gazette is already published and technically the company is dissolved, it will then cease to exist and dissolve and no longer be able to conduct any form of business or transaction. So once it's already gazetted, you can no longer use a name, the title of the company to say that I have a business dealing with you under this company, but in fact the company has already been dissolved. So you can no longer use the company's name because the company no longer exists in law. However, under Section 554 of the Companies Act, the liabilities of a director, officer, or member of the company continues and may be enforced as if the company has not been dissolved. Now, this part is a little bit tricky. Why? It's because in legal terms, the company has already been dissolved. It has already been gazetted and already struck off the register, which means that as a director, I shouldn't be hold any liabilities of the company anymore because it no longer exists. But here the problem is, whenever it's where the company is struck off, it can be dissolved, but the liability will still remain. And sometimes, perhaps, let's say a creditor or anybody else had previous dealings with the company, found out that, for example, in one scenario, there's a fraudulent transaction or there's a trading which resulted in tort or contractual breach or whatnot, then that person will have to reinstate this company, bring a legal action against this company, and technically speaking, the director or officer or member of the company will put in place of the company and be sued by these parties unless they reinstate the company. Like what I said, there may be some objections for a company to be struck off. There may be person interested objecting to the strike off application. It's essentially the same thing. Let's say if someone heard that this, let's say company A is getting dissolved, is getting struck off, and they still owe this person probably around, let's say, 500,000 in cash terms without any contract or agreements, then perhaps what they can do is they can object to the striking off on the following grounds under Section 552. The first one is to show that the company is still carrying on business. The company is a party to legal proceedings. It is in receivership or liquidation or both. and the person is a creditor or the member or a person having charge claim against the company. So essentially, let's say this company A owes me 500,000. I am a creditor, so I have undischarged claim against the company. So I can go for it and say that, look, I am objecting the company's A's striking off because technically speaking, they still owe me 500,000. This is undischarged claim against the company. So there also exists a right. The next one is there's a right of action on behalf of the company. Let's say this company A borrowed this 1 million to company B, and after that, some people decided to think, oh, this company B borrowed 1 million from company A, which I have indirect benefit. So I should also sue on behalf of this company A to get back. That's why company A can't be struck off yet, something like that. Or for any other reason, it would not be just and equitable to remove the company from the register. So as long as there's any other reasons or other grounds that can convince the register and say, look, if you strike off this company from the register, I will suffer this and this, then probably the registrar will take into consideration and just say, okay, it will not be just and equitable to strike it off first, and I will reject the application or whatnot. However, under the same section 552, the registrar will not proceed with the striking off unless the objections have been withdrawn, the relevant facts of the objections are no longer correct or relevant, or the objection is basically just a made-up, frivolous and vexatious claim. Lastly, when we are talking about striking off a company, let's say you have already filed a striking off application to the SSM, and out of a sudden, there's this big contract opportunity coming in, asking you, hey, we have this multi-million business opportunity, do you want to work together? And you decide that, oh, maybe it's not the right time to really terminate or strike off the company's operation. So within 30 days from the notification issued by SSM, you must lodge a notice of withdrawal to withdraw your striking off application to the registrar, together with the reasons for withdrawal application and the supporting documents. So let's say, like the same scenario, if company A wants to strike off, company B approaches company A, asks for a business collaboration, which would result in a multi-million profit or whatnot. Company A, upon getting the notification, within 30 days, would have to lodge a notice of withdrawal with SSM and say to the registrar, I do not want to strike off my company anymore because I have this business opportunity coming up and it's going to be a few years' time down the road. So you can also attach together, let's say, the letter of correspondence between the company A, company B, and also the contract to support your withdrawal. So it would be slightly easier for them to do it. So overall, striking off application of a company, it's a very straightforward and quick process. Usually, unless you have a lot of different disputes or in terms of your liabilities and debts, it's a very simple process. It just requires the members, directors, and also the SSM. Once you launch an application to SSM, within 6 to 12 weeks, you get your notification, and after that, you're gazetted and your company is off the register. That's all for my sharing. I will pass on to the next speaker, Sebastian, who will be talking about voluntary winding up. Sebastian, over to you.
Thank you, Aaron, for your valuable insights on the dissolution and the striking off of a company. My name is Sebastian Liew, and I will be the second speaker for today's online talk session, and I will be speaking on voluntary winding up in Malaysia. I will begin today's session by speaking briefly on the winding up process in Malaysia, members' voluntary winding up, and creditors' voluntary winding up. I will begin with some background on what a winding up is. In Malaysia, the winding up or the liquidation of a company is governed by the Companies Act 2016. Winding up is the process where a company's assets are collected and used to pay off its debts and liabilities. Any surplus is then distributed among the contributories, also known as the shareholders or the members of the company, according to their rights and interests, or otherwise be dealt with as the constitution or the articles, whichever applicable, of the company directs. Upon the completion of the winding up or liquidation, the company will be dissolved and will no longer exist after winding up. There are several common reasons for closing a company by the winding up process. Typical reasons for winding up a company includes the cessation of trading or business activities, the company's inability to pay its debts. It is just and equitable that the company is wound up. The company is in default of lodging the necessary statutory documents, and the company's parent or holding company decides on a corporate restructuring exercise or strategy. So the next question would be, what are the types of winding up that are available in company law? There are two ways in which a company may be wound up in Malaysia. One approach is by way of a compulsory winding up, and the other approach is by way of a voluntary winding up. The process of winding up will differ in accordance with the need for the court's involvement. For the first approach, a compulsory winding up requires the presentation of a petition for winding up to the court. For the second approach, a company may voluntarily be wound up by either its members or its creditors. Here, the company's shareholders or its creditors will have to pass a resolution to wind up the company. This process does not involve the courts. As discussed in the previous slide, I will briefly explain the first approach, which is a compulsory winding up. A compulsory winding up is where the court makes an order to wind up a company after a party presents a petition in court. This approach, as mentioned, requires an application to the courts. Under Section 464 of the Companies Act 2016, the petitioners may include the company, the creditors, including a contingent or prospective creditor of the company, a contributory or a personal representative of a deceased contributory, or the Director General of Insolvency of the estate of a deceased contributory, the liquidator or the official receiver, or the registrar of companies. Section 465 of the Companies Act 2016 provides the circumstances in which a company may be wound up by the court. The common circumstances for a company to be wound up by the court are where the company is unable to pay its debts. The threshold is where the company owes a debt exceeding 50,000 ringgit. Or the court is of the opinion that it is just and equitable that the company be wound up. Some examples are management deadlock, shareholders dispute, oppression of minority shareholders. Once an order of court to wind up the company is obtained, the court may appoint a liquidator to wind up the affairs of the company. Where no liquidator is appointed, the official receiver shall be the liquidator. So as our focus for today's session is on voluntary winding up, we will not go into any further details on compulsory winding up. I will now move on to our main focus, which is the second approach in which a company may be wound up in Malaysia, which is voluntary winding up. So for voluntary winding up, under the Companies Act 2016, there are two types of liquidation by voluntary winding up. The first type is the members' voluntary winding up, and the second type is the creditors' voluntary winding up. In assessing the appropriate type of voluntary winding up, this would depend on the nature of solvency of the company in question. In short, members' voluntary winding up is applicable where the company in question is solvent, whereas creditors' voluntary winding up is when the company in question. Both members and creditors' voluntary winding up generally does not involve the courts. Special resolution is required. A company may be wound up voluntarily if the company so resolved by special resolution. This is pursuant to Section 439 sub 1b. A special resolution is a resolution where a notice of not less than 21 days has been given and passed by a majority of not less than 75% of those entitled to vote on a written resolution. The next step is that a company shall lodge a printed copy of the resolution with the registrar within 7 days from the passing of a resolution for voluntary winding up, as required under Section 439 sub 2a. A company shall also give notice of the resolution in one widely circulated newspaper in Malaysia, in the national language and in the English language within 10 days after the passing of the resolution. This is required under Section 439 sub 2b. A voluntary winding up shall then commence at the time of the passing of the special resolution for voluntary winding up, and not the date the notice was lodged or circulated. We will now begin the members' voluntary winding up segment of today's online talk. As mentioned, this is a winding up by the members without the involvement of the courts or creditors of the company. Under Section 432 sub 2a of the Companies Act 2016, a member's voluntary winding up may be effected by a resolution where the company is solvent and the liquidator is appointed by the members at the members' meeting. A member's voluntary winding up is a suitable option for a company that can pay its debts, but the member or contributories want to close it. The date of commencement of the member's voluntary winding up shall be the passing of the member's resolution to initiate the winding up at a meeting of the members. Under Section 443 of the Companies Act 2016, where it is proposed to wind up a company voluntarily, the majority of directors or the director, in the case of a company having only one director, may make a written declaration to the effect that an inquiry have been made into the affairs of the company, and at the meeting of directors have formed the opinion that the company will be able to pay its debts in full within a period not exceeding 12 months after the commencement of the winding up. The declaration shall be made before the date the notices of the meeting containing the agenda proposing to wind up the company are sent out to the members of the company. Do note that this declaration shall have no effect unless it is made at a meeting of directors, made within 5 weeks immediately preceding the passing of the resolution for voluntary winding up, and lodged with the registrar before the date the notice of the meeting at which the resolution for the winding up is proposed to be sent out to the members. A statement of affairs of the company shall be attached to the written declaration. This statement of affairs should be made up to the latest practicable date before the written declaration is made. The content of the statement must include the assets of the company and the anticipated amount to be realized, the liabilities of the company, and the estimated expenses of winding up. Breach of declaration of solvency. As the Companies Act requires the director to make an inquiry into the affairs of the company before making the written declaration of solvency, forming an opinion that the company satisfies the solvency test for a member's voluntary winding up, a director who makes a declaration without having reasonable grounds for the opinion that the company will be able to pay its debts in full within the period stated in the declaration commits an offence and shall, on conviction, be liable to imprisonment for up to 5 years or a fine not exceeding 3 million ringgit or to both. If the offence is continuing after conviction, a further fine not exceeding 500 ringgit each day. Further, if the debts of the company are not paid or provided for in full within the period stated in the declaration, it shall be presumed until the contrary is shown that the director did not have reasonable grounds for his opinion. The liquidator in a member's voluntary winding up. Under Section 445 Sub 1 of the Companies Act 2016, in a member's voluntary winding up, the company shall appoint one or more liquidators for the purposes of winding up the company's affairs and distributing its assets in general meeting. Liquidator may be removed by special resolution, of which special notice have been given to the creditors, and the liquidators in a general meeting convened by any contributory. To elaborate, once a liquidator is appointed, all the powers of the director ceases. A liquidator can only be removed in a general meeting of the company after 28 days notice have been given, and where the resolution to remove the liquidator is passed by a majority of not less than 75% of the members. However, in certain circumstances, a liquidator may not even be removed in general meetings. A broad example is where the liquidator or a creditor has obtained a court order prohibiting the removal of the liquidator. In such a situation, any resolution passed shall not be effective. Converting a member's voluntary winding up into a creditor's voluntary winding up. In a member's voluntary winding up, where the directors have provided the written declaration and statement of affairs, if the liquidator is of the opinion that the company will not be able to pay or provide for the payments of its debts in full within the period stated in the written declaration, the liquidator shall summon a meeting of creditors. At the meeting of creditors summoned by the liquidator, the creditors may choose to continue with the liquidator appointed by the company, or to appoint any other person to be the liquidator. Once a meeting of creditor is held, the winding up shall proceed as if the winding up were a creditor's voluntary winding up. The additional effect would be as if the written declaration of the directors, as required under members' voluntary winding up, had not been made. Moving on, we will now begin the creditor's voluntary winding up. To recap, the fundamental distinction between a member's voluntary winding up and a creditor's voluntary winding up is the written declaration of solvency by the directors of the company under Section 443. Therefore, in a case where a 443 declaration has not been made, a voluntary winding up is a creditor's voluntary winding up. Creditor's voluntary winding up. Under Section 449 of the Companies Act 2016, the company shall cause a meeting of its creditors to be summoned for the day or the next day on which the meeting for the resolution for voluntary winding up is proposed. Therefore, under Section 449 Sub 1, the creditors' meeting can either be held right after the meeting where the company resolves to be voluntarily wound up, or the next day after the meeting to wind up is held. Under Section 449, Sub 2 of the Companies Act, the notice of the meeting of creditors shall be sent by post to the creditors simultaneously with the notices of the meeting of the company. There are certain prerequisites that need to be complied with before the meeting of creditors is held. The first is that the time and place of the convened meeting must be convenient to the majority in value of the creditors. The second is that there must be at least 7 clear days notice by post of the meeting must be given to the creditors. The third is that the notice shall be advertised at least 7 days before the date of the creditors' meeting in one widely circulated newspaper in the national language and one widely circulated newspaper in the English language. Moving on, after the prerequisites have been complied with, the next step is to hold the meeting of creditors. At the meeting of creditors, the creditors will consider the company's proposal for a voluntary winding up. At the meeting of creditors, an appointed director and the secretary of the company shall disclose the company affairs and the circumstances leading to the voluntary winding up. The creditors may appoint one of their own or a director in attendance to preside the meeting. This means this person appointed by the creditors shall be the chairperson of the meeting of creditors. The chairperson shall then determine whether the meeting has been held at a time and place convenient to the majority in value of the creditors, and his decision shall be final. If the chairperson decides that the meeting has not been held at a time and place convenient to the majority, the meeting shall lapse and a further meeting shall be summoned by the company as soon as feasible. Feasible does not mean as soon as possible. Rather, it must be done within a reasonable time. Therefore, the next meeting of creditors should be summoned as soon as reasonably can be expected in the particular facts and circumstances. Liquidators in creditors' voluntary winding up. Under Section 450, Sub 1 of the Companies Act 2016, the company shall and the creditors may, at their respective meetings, nominate a person to be a liquidator for the purpose of winding up the affairs and distributing the assets of the company. Under Section 450, Sub 2 of the Companies Act 2016, if the creditors and the company nominate different persons, the person nominated by the creditor shall be liquidator, and if no person is nominated by the creditors, the person nominated by the company shall be liquidator. In a creditor's voluntary winding up, similar to a member's voluntary winding up, once a liquidator is appointed, all the powers of the directors ceases except if the continuance of powers is approved by the creditors. In the event there is a casual vacancy in the office of the liquidator, for example, due to death or resignation, any two creditors may summon a meeting of creditors to fill the vacancy. Provisions in the Companies Act that are applicable to liquidators in every voluntary winding up. We have dealt with the specific requirements for liquidators in a member's voluntary winding up and a creditor's voluntary winding up. There are, however, several provisions in the Companies Act that are applicable to liquidators regardless if it involves a member's or a creditor's voluntary winding up. Provisions in the Companies Act 2016 that are applicable to liquidators in every voluntary winding up are as follows. Under Section 453 Sub 1, where there is no liquidator acting in a voluntary winding up, the court may appoint a liquidator. Under Section 453 Sub 2, the court may, on cause shown, remove a liquidator and appoint another. Such an application may be made by any director, member, or creditor. Under Section 454 Sub 1, a liquidator shall be entitled to receive salary or remuneration. Under Section 455 Sub 1, acts of a liquidator shall be valid, notwithstanding any defects that may afterwards be discovered in his appointment or qualification. Therefore, any defects or irregularity in the appointment of the liquidator does not invalidate the act of the liquidator and shall be valid unless there is bad faith. So now what happens if the winding up continues for more than 1 year? Under Section 458 Sub 1 of the Companies Act 2016, if the winding up continues for more than 1 year, the liquidator shall summon, in the case of a member's voluntary winding up, a meeting of members of the company, and in the case of a creditor's voluntary winding up, a meeting of members of the company and the meeting of creditors. Such meetings shall be summoned at the end of the first year from the commencement of the winding up, and of each succeeding year, or not more than 3 years after the succeeding year. I think this is of not more than 3 months after the succeeding year. Basically, the liquidator has a duty to summon annual meetings for each succeeding years after the voluntary winding up exceeds 1 year. At the annual meetings, the liquidator shall lay before the meeting an account of the acts of the liquidator and dealings and of conduct of the winding up during the preceding year. So now what happens after the liquidation process is completed and the assets of the company has been realized? Section 459 sub 1 of the Companies Act 2016 provides that as soon as the affairs of the company are fully wound up, the liquidator shall, under subparagraph A, prepare an account showing how the winding up has been conducted and the property of the company has been disposed of. And under subparagraph B, call for a meeting of members of the company, or in the case of a creditor's voluntary winding up, a meeting of members of the company and creditors. The quorum at a meeting of members shall be 2 members, and the quorum for a meeting of creditors shall be 2 creditors, for the purpose of laying before the meeting the account and for giving any explanation where necessary. The liquidators must fulfill certain statutory conditions before the final meeting of members or creditors is held. Section 459 sub 2 of the Companies Act provides that the final meeting shall be called by an advertisement specifying the time, place, and object of the final meeting, and shall be published at least 30 days before the date of the final meeting in one widely circulated newspaper in the national language and one widely circulated newspaper in the English language. A liquidator who fails to call a meeting as required under Section 459 commits an offence and shall be liable to a fine. Under Section 459 sub 3 of the Companies Act 2016, after the final meeting had been held, the liquidator shall lodge with the registrar and with the official receiver a return of the holding of the meeting and of its date with a copy of the account attached to such return within 7 days from the date of the meeting. A liquidator who does not lodge the return commits an offence and is liable to a fine. On the expiration of 3 months after lodging of the return with the registrar and with the official receiver, the company shall be dissolved. Upon dissolution, the company can be taken to be fully closed. On that note, that's my part on today's topic, and I will now pass the floor back to our moderator. Thank you.
Thank you very much, Sebastian and Aaron, for your insights on the dissolution, voluntarily winding up, and the striking off of a company. We are a little bit short on time. We will not be able to address all of the questions posed to us today. I think we can take 2 questions at best. So for the first question, I think Aaron can answer this. For the reinstating of the company, does it mean that the director needs to apply to SSM to undo the striking off process?
So for reinstatement of a company, it's technically speaking, it's not really a matter to undo the striking off process. More so, it's because the company has already been struck off. So it's no longer in the SSM's register. So you will need to reinstate the company for a lot of different reasons. For example, there's assets, there is business operations going on, and it's not a dormant company because clearly the company has conducting business from day to day lah. But whether it means director needs to apply to SSM. Usually, since the company has already been struck off, usually we will go to the court to get a high court order to reinstate the company and to put it back into the register. This also involves a lot of different processes, liaising with the high court and also with SSM. So it's not just SSM only, but also would involve high court as well. Yep, hope that answers.
Thank you, Aaron. And I think the next question you would be able to answer as well. If the company, in brackets, our client, still owe us money, but the directors engaged a legal firm to apply for striking off and it was successfully struck off by SSM, what can we do?
This question has a certain similarity with the previous question. because it also touched on reinstatement as well. So if the company still owes you money, but it's already been struck off and successfully struck off by the SSM, what can you do? So obviously the first thing is you have to look at the Gazette and see whether the notice of publication of the striking off of the company has already been gazetted in the Gazette or not. So like I have shared earlier just now, within 30 days from the date of it being published or gazetted, you have to file a notice of withdrawal, object something similar to that. The first option is objecting the striking off. The second option is, let's say, because definitely you won't be able to find out that the company has already been struck off until, for example, let's say SSM approved my striking off application today, and after 3-4 months later, I still owe you money, but I already struck off myself, and you only found out that, oh, this company has already struck off, but it's already been struck off for more than 3-4 months. What can I do? The next option for you to do is to reinstate the company as a creditor on the grounds that there are monies owed by the company to you as the creditor. So this is one of the ways for you to be able to get back your money, go to the court and say that, look, we need you to reinstate the company on the grounds that they still owe us money. And if you're not going to reinstate it, it will be unjust and inequitable for us because it's unfair to us. We already borrowed the money to the company and they have already struck off. So this is one of the reasons to reinstate the company as well. Yeah, I hope this also answers your questions.
Thank you, Aaron. And I think we have time for one final question in light of the time now. Perhaps Sebastian can answer this question. Between hire purchase creditor and debenture holder, who is to be paid first, since both have charges over company assets?
So the general position is that hire purchase creditors hire purchase agreements are a form of asset financing. And typically, as it involves the banks, they are typically treated as secured creditors. Whereas debenture holders hold a type of debt security, so they are essentially treated as unsecured creditors in the event of a company's insolvency or liquidation. To answer the question, basically we have to pay the hire purchase creditors before the debenture holders.
Thank you very much, Sebastian. And I'm so sorry, but we will be unable to answer the rest of the questions as we are running out of time. But before we conclude, I do have a few announcements to make. Firstly, please join us again for our upcoming talks. Our next few talks will be on the 18th of October by our partner, Mr. Gan Chongche, and our associate, Joseph Kaur. And they will be speaking on the contempt of court, forcing compliance with orders through committal proceedings. Following which, our next talk is scheduled on the 25th of October, and that will be given by our senior associate, Mr. Jeremy Balang, and myself. And it will be on understanding damages for medical negligence, the types, trends, and tactics. And secondly, please fill up our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat below. Thirdly, please do follow or like our social media accounts, the links to which are on your screen right now. And lastly, if you would like to speak with our lawyers, we do offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website, the link to which is posted in the chat box below. And finally, to all our guests, thank you very much for joining us today. We hope that you would have found our session today informative and useful. Thank you, everybody, and we will see you at our next talk.